The duality of dominion, force and paper in modern tyranny. 1. The instrument of force, a crude symbol of tyranny. The firearm, emblematic of coercion and destruction, represents an overt and unsophisticated method of imposing control, typically reserved for regimes unable to maintain subtle mechanisms of dominance. Footnote: tyrannies reliant on force alone reveal both their desperation and their lack of institutional sophistication. 2. Paper as the sophisticated tool of control. In contrast, modern administrative regimes deploy paper, registrations, licenses, permits, and tax forms, as covert tools of governance, relying on the psychological threat of force to compel compliance with bureaucratic demands. Footnote: bureaucratic tyranny cloaks violence under a veneer of procedural legitimacy. 3. The power and potential of the affidavit. An affidavit, a sworn declaration under penalty of perjury, functions as a unilateral legal instrument possessing the force of law unless challenged by a timely and substantive rebuttal. Footnote: the affidavit reverses power dynamics by leveraging silence as tacit agreement. 4. Affidavits in private contracts, shifting the legal landscape. By strategically deploying affidavits, e.g., in mortgage disputes or contractual counter-offers, an individual may impose enforceable terms that reorient obligations unless expressly denied or rebutted. Footnote: silence in response to an affidavit can create binding legal obligations by presumption. 5. Corporate use of default terms and the individual's right to respond. Financial institutions routinely revise agreements unilaterally via terms and conditions mailers, which become binding contracts upon the recipient's silence. However, this principle equally empowers individuals to propose counter-terms with equal force. Footnote: consent by silence is a two-way doctrine and may benefit either party depending on initiative. 6. Affidavit as a defensive and offensive legal instrument. Properly structured affidavits carry the presumption of truth and must be rebutted or they stand as law. If ignored, they form a foundation for legal claims, including financial demands and modifications of contractual obligations. Footnote: the affidavit elevates the private individual to a position of lawful authority. 7. The pitfalls of signing external contracts. Documents drafted by institutions inherently serve their authors. Signing without modification often constitutes self-incrimination or unintended concession, while drafting one's own terms reclaims agency. Footnote: authorship of contract language is inseparable from control over legal meaning. 8. Procedural requirements for a valid affidavit. An affidavit requires a statement of facts, a declaration of truth, a signature, notarization, and service to the affected party with sufficient opportunity to respond. Its simplicity belies its legal gravity. Footnote: simplicity of form does not diminish the binding nature of an affidavit. 9. Institutional vulnerability to incoming notices. While institutions excel at issuing demands, they are frequently ill-equipped to process incoming legal instruments, thereby exposing systemic gaps which individuals may exploit via procedural rigor. Footnote: institutional bureaucracy often collapses when subject to its own procedures. 10. Legal sovereignty through private terms. By refusing adhesion contracts and offering counterterms through sworn instruments, the individual reasserts contractual sovereignty, transforming involuntary compliance into mutual assent. Footnote: the right to contract includes the right to reject and to propose. 11. Paper revolution, mail as a medium of lawful rebellion. Paper, like the musket, may be wielded to initiate lawful revolution. When used with precision, it shifts control from institutions to individuals without violence, through procedural assertion of rights. Footnote: the pen remains mightier than the sword when wielded by the informed. 12. Caveat: paper as a double-edged sword. Legal documents must be crafted and deployed with care, as uninformed use of affidavits can backfire. Knowledge of procedure, jurisdiction, and evidentiary standards is imperative. Footnote: legal instruments are powerful only when applied with confidence.